Desmond Lee. It's only one, sir.
I thank Mr. Lee for his question. The Ministry of Law introduced a disclosure regime in the CPC 2010. This change in the law was generally welcomed. During the second reading, I had said the following in respect of general disclosure obligations. I quote, lawyers appearing in court, whether prosecution or defense lawyers, are officers of the court. If they deliberately suppress material evidence, they will be acting in gross breach of their duties. One cannot put forward evidence in court while holding back other evidence which could put a different complexion on the evidence that has in fact been tendered in court. I have no doubt that the court will take a serious view of such conduct. Close quotes. In Kadar's case, the Court of Appeal referred to and relied on this statement and explained the nature and extent of the prosecution's duty to disclose material in its possession which it does not intend to use as part of its case. The Court of Appeal held that the prosecution is under a legal duty to disclose two types of unused material in its possession. One, unused material which is likely to be admissible and might reasonably be regarded as credible and relevant to the guilt or innocence of the accused. And two, unused material which is likely to be inadmissible but would provide a real chance of pursuing a line of inquiry that leads to material that is likely to be admissible and that might reasonably be regarded as credible and relevant to the guilt or innocence of the accused. Any doubt on these issues is to be resolved in favor of disclosure. Mr. Speaker, sir, the government, the judiciary, and the public prosecutor are all charged with and concerned that each and every accused person have available all relevant and credible material in the prosecution's possession that may aid his or her defense. The application of the principle is a matter of judgment in each case. The prosecution must assess its disclosure obligations professionally and in good faith. In the Kadar case, the Kadar brothers, Muhammad and Ishmael, were initially charged for the murder of the victim in the flat she shared with her husband. The husband of the victim told the police that there was only one assailant. This was recorded in a statement dated 4th of September 2005. The prosecution did not, at first, disclose the husband's statement. The presence of both the accused persons at the scene was not initially disputed, though later Ishmael disputed this when he gave notice of an alibi. Second, the husband was in poor health and immobile at the time of the alleged crime. He was in the bedroom while the victim was killed in the living room, and he could only give his statement through gestures. He could not speak. Prosecution took the view that the husband was in no position to know how many assailants there were and that his evidence was unreliable. In March 2007, while the trial was ongoing, counsel for Muhammad and Ishmael informed the prosecution for the first time that Muhammad was taking sole responsibility for killing the deceased. The trial was too down for the prosecution to consider its position. Separately, defense counsel also applied to discharge themselves. The prosecution decided to proceed against Muhammad and Ishmael as charged. Given Muhammad's position, the prosecution on the 4th of September 2007 disclosed Mr. Lowe's statement, which had been made on the 5th of September 2005 to the defense. This was 6 days before the trial resumed on the 10th of September 2007. Two sets of interview records, which were made before the statement was recorded and were in the same terms as the statement, were also subsequently disclosed. Court of Appeal took the view that on the facts, the husband's statement and the interview records should have been disclosed earlier. I think the conclusion is one which most lawyers will agree with. I have consulted with the Attorney General on the changes in prosecutorial practice arising from Kadar. The Attorney General's chambers have taken into account the Kadar judgment when assessing the disclosure obligations in each case. The process begins early at the pre-trial stage and continues until the conclusion of the case. Prosecutors have also been briefing investigators on the requirements laid down in Kadar. Investigators who are alive to the issues can effectively assist the prosecution in fulfilling its disclosure obligations. Since the enactment of the CPC 2010, AGC have been working on a joint code of practice for prosecutors and defense counsel, which will carry general guidance on disclosure. At the same time, the criminal bar and prosecutors from AGC have also engaged in discussions to work out guidelines on the prosecution's disclosure obligations under Kadar. Thank you, sir.
Order. End of question time.